Welcome to Wyoming's Health Watch. I'm attorney Jason Oakes, and here you'll learn the most up-to-date information about dangerous drugs, dangerous products, and safety news with hopes that it just might prevent a catastrophe. Let's get started.
Good morning. This is November 21st, and I want to provide just an overview of kind of the most pressing and most top-of-mind awareness litigations that are going on right now, and how these are shaping various legal issues that are before the courts right now. First and foremost, I tweeted earlier this week about a smoking lawsuit that resulted in a verdict of $157 million. And a lot of people, I got a lot of responses on that. A lot of people are like, how can you sue for smoking? And I had no idea that smoking was still being litigated. And in fact, it is. Florida is one of the only, I think it's the only state, as a matter of fact, that still permits smoking cases to be litigated. And that was the result earlier this week of a individual who brought a wrongful death lawsuit against Philip Morris and R.J. Reynolds for the lung disease that his spouse received from smoking. And these are primarily fraud and non-disclosure cases. And so the majority of the $157 million was actually not the majority, about half of it, $74 million, was for punitive damages for the failure to disclose the real risk behind smoking, and the jury's very upset is how the companies knew that nicotine was so addictive, and yet manufacture their cigarettes in a way to more easily get that nicotine into your body, and therefore create an addictive component to that ritual, if you will. But what's unique about this case, and probably a first of its kind, is like I said, it was a wrongful death case, and in my experience, if you are not married at the time that you are quote unquote injured, and injured being the triggering event for the lawsuit, then you do not have a claim as a spouse for that injury. In other words, you have to prove that you were married at the time. And this case was remarkable because it was the first same-sex couple case that they believe has gone forward, certainly in a smoking context. And in this situation, the spouse who had died from lung disease had contracted the lung disease prior to 2015 when the couple got married. The couple was married in 2015, but the lawyers in that case did an excellent job. They argued that the reason they got married in 2015, as opposed to earlier, was because it was illegal in Florida to marry as same-sex couple until 2015. And they were able to convince the jury that if there had not been a law that made it illegal, that they would have gotten married earlier, and therefore they would have been married at the time that the spouse who died contracted the lung disease, and therefore he would have had an argument and standing under the law to bring the lawsuit. The jury agreed, and the jury found that the living spouse had proper standing to bring the lawsuit in spite of the fact they were not officially married at the time the lung disease was contracted, and nonetheless found in favor of the living spouse and ordered $157 million awarded against Philip Morris and R.J. Reynolds. So, remarkable case. Now let's shift to the climate change crisis litigation that I've been talking about for months now, and I think I'm about the only one in the country talking about this, and I'm particularly focused on it because I live in Wyoming, a state that is highly reliant on fossil fuel industry for all sorts of revenue that generates our state. We do not have income tax in Wyoming, so we have an enormous reliance in this regard. And I have been beating this drum over and over that these issues about climate change, and I think even gun control, I did a podcast on that, are going to be decided by individuals sitting as a jury as opposed to politicians. And states like Wyoming and Texas and Utah and even Colorado need to take notice of this, and they have to pay attention to it. In any event, The latest on the climate crisis litigation is that two major defendants, Suncor Energy USA and, of course, ExxonMobil, who we've all heard of, they were sued in state court in Colorado, again under a public nuisance argument, arguing that they had contributed and are liable for climate change-related harm in that lawsuit. And that lawsuit was removed to federal court by the defendants. The plaintiffs in that case filed what we call a motion to remand, which is a motion to say, hey, this doesn't belong in federal court and needs to go back to state court. They won that motion. The federal court agreed with the plaintiffs that it needs to go back to state court. And now Suncor Energy and ExxonMobil have appealed that order to the 10th Circuit, basically begging the 10th Circuit to overrule the motion to remand and send it back to federal court where it makes, from their standpoint, more sense for the case to be. I have looked at the briefing. I think Suncor and Exxon are going to lose, but what they have created is at least delayed the state court with this appellate filing. The reason they want to be in federal court is federal court has higher standards in terms of expert disclosures. It's just a more cumbersome process. It moves slower, whereas the state court moves very fast, and they just don't want to deal with their day of reckoning in court. So they're avoiding state court as much as they can. Also, federal court pulls jurors from all over the state. So in federal court, they're going to get a mixture of both, right jurors, I would call them, and left jurors, instead of state court, which typically gets, especially in Colorado now, just left jurors. And so places like Wyoming and Texas are not going to get these lawsuits. They're not going to be brought in those states because the likelihood of winning is very low. But the likelihood of winning in blue parts of Colorado and blue parts of, in Oregon and California, and there's also a major lawsuit going on against Exxon as we speak in New York. That's where the cases are going to be brought. That's where the cases have the most likelihood of prevailing on the plaintiff's side, and that's where significant issues are going to occur, not only in terms of awarding potentially astronomical damages, but when those damages occur, if they do, and I think there's a high likelihood they could. Others will take notice, and others will want to jump on the bandwagon, file cases, and bring those cases forward, which will create a whole dearth of climate crisis litigation lawsuits on top of those that are already in existence. Let's shift gears quickly. I thought it was interesting that a Floridian vegan filed a lawsuit against Burger King, claiming that their Impossible Whopper is not beef free because it is cooked on the same grill as their other beef patties, and therefore particles of beef gets on the Impossible Whopper. We'll see where that one goes. I'm not a big fan of those kind of cases, but nonetheless, I thought it was somewhat newsworthy. And then finally, Johnson & Johnson, I've been talking about them a lot. They've received our award for the worst company of 2019. I think they are fast trying to hold on to that award for 2020. But the good news is that Johnson & Johnson took a class action to trial in Australia just this past month. There was 1,350 Australian women that were part of the plaintiff class, suing them as a result of the pelvic mesh implants that were used to surgically treat urinary incontinence and pelvic organ prolapse. But they did not sufficiently warn women about the risks, is what the plaintiffs contended. It was a bench trial in Australia, and the judge did find Johnson & Johnson responsible. The judge has set February for the next hearing in the case where damages will be discussed, and I suspect that will be an enormous number. That's your update for the litigation for Thursday, November 21st, 2019. I hope you have a great rest of your day. Please go to WyomingHealthWatch.com if you want to listen to our other mini podcasts or videos. Have a great day. I'm Jason Oakes.